Okay, perfect. So, good morning, everyone, and welcome to our last scientific seminar. And it was really great to see you every month online. And it will be even better to see you next month in Warsaw personally. Um, as this is our last seminar, this is, well, of course, you are free to talk whatever you want, but it would be great to, well, to summarize all our, good morning, Michal, all the researches. And it would be also great to have some conversation after. So, what if you give your presentations in some 15 minutes, and then we have the time for discussion. Marta, would you start? Then now Poland first, Hungary second, if you don't mind.
Okay, there's no problem. And at our last meeting, I discussed the Polish legal solution of the issue of pharmacist conscience in the context of the possible introduction of a conscience clause in Polish legislation. It should be emphasized that in Poland there is no legal basis for such this legal construction, the pharmacist conscience clause. However, there are dilemmas of the formal, moral, and ethical nature in the professional group. It's therefore worth considering that they come from, for example, what their source is, as well as analyzing the voice of those involved. Therefore, today I would like to present these are two issues. So, situation of the possible conflict of conscience in the work of the pharmacists and their opinion of the pharmaceutical community of the conscience clause. A pharmacist's duty is to protect the life and health of patient, and therefore pharmacist guided by the principle should have the right to choose. There is no doubt that the legislation of the conscience clause, like the introduction of the universal pharmacist care, represents a significant challenge on the Polish market. The individual right to freedom of conscience and religion is the basis of the democracy functioning of our country, and it's on the right to the conscience clause is based on not on the Christian principles, with which is the often identified. It's guaranteed the possibility to oppose certain practices to Catholic as well as those who are not guided by religion but the ethical principles and scientific evidence. It's obvious for us. But this provision does not restrict women's freedom and does not legally issue hormonal contraception. Such drugs would continue to be sold in pharmacies while respecting the moral values of the pharmacies dispensing them. It should be noted that the right to refuse to sell product would apply not only to hormonal contraception but also to the other product whose use may be harmful to the patient. For example, Botox, or which arose controversies such euthanasia kits prepared in hospital pharmacies or product available in open pharmacies which are used to assist suicide or product use in vitro fertilization in which many embryos are destroyed. Conscientious objection is a legal standard in the medical profession and guaranteeing that Polish pharmacies would be significantly raise the prestige of the profession, placing it on the equal footing with other health professionals. It should be noted that due to the lack of the legal basis explicitly regulating the pharmaceutical conscience clause, exercising it may be associated with serious negative legal consequence for the pharmacies. For example, repeat refusal to sell a medicine or fill a prescription could be considered a perceived failure to meet the need of the public, potentially leading the withdrawal of the pharmacy license. A refusal to sell a medicine or fill a prescription could also potentially be considered an unlawful infringement on the personal good of the right to family planning. A refusal to sell a medicine without a legitimate reason may also be considered an offense which may involve a fine. A refusal to sell medicine may also be considered a breach of employment duties for which the employee is liable under labor law. In practice, a pharmacist wishing to use the conscience clause should take into account the fact that the differing opinions of the authorities on the legal permissibility is refusing to dispense a medicine motivated by religious or philosophical beliefs may also translate into different practice in the pharmaceutical inspection in the event of receiving a report of a violation of pharmaceutical law. It's also difficult to predict the direction in which the jurisprudential practice in common courts will develop the regard to violation of personal rights related to the refusal to sell contraceptive drugs, in particular in the context of women's reproductive rights. In Poland, the Association of the Catholic Pharmacists in Gdańsk, together with a Human Life International Poland, has started collecting signatures for appeal to enable Polish pharmacists to use the conscience clause. It was in 2010. The similar to the start in the initiative was Council of Europe resolution calling the observance of the conscience clause right of medical professionals. Activities intensive in 2015 when the European Commission allowed the over-the-counter sell the ELA-1, the product belonging to so-called emergency contraception. The main issue raised by the association in the conflict of conscience occurring in the sale of pharmaceuticals that destroy human life and human fertility. We can therefore pose the question, is the pharmacist a salesman or a medical profession? According to the Article 7 of the Code of Medical Ethics in Poland, in particular justified cases, a doctor may not undertake or refrain from treating a patient except in case of urgency, in not undertaking of without drawing for treatment. The doctor should indicate to the patient another possibility of obtaining medical assistance. The pharmacist is not a different situation. The doctor's responsibility is to choose the appropriate treatment, while the pharmacist provides the patient with the medicine prescribed by the doctor. And at this stage, the question arises at the pharmacist's role and authority to interfere in the doctor-patient relationship. Opponents of the conscience clause argue that he is merely a seller of medicines, while according to the proponents, he exercises pharmaceutical care over the patient in the broad sense and in therefore practicing a medical profession. And who is right? The definition of the medical profession is contained in the Act of Medical Activity. Polish Act of Medical Activity. According to it, a health professional is a person authorized to provide health services, which are understood as activities aimed at the preserving, saving, restoring, or ameliorating health and other medical activities resulting from the treatment process. And according to the Article 2 of the Act of Pharmacy, chambers, the exercise of the profession and pharmacists is aimed at protecting public health and includes of the provision of pharmaceutical service. As a result, it can be concluded from this that pharmaceutical care is such a service, and therefore the pharmacist can refer the aforementioned resolution of the Parliamentary Assembly of the Council of Europe. On the other hand, however, Article 96 of the pharmaceutical law, Polish pharmaceutical law, impose an obligation on the pharmacy to have medicinal product and medicinal devices in the quantity and assortment necessary to meet the health needs of the local population. In addition, pharmacies are obligated to ensure the availability of medicine and special purpose products with which a funding limit has been established. Admittedly, the provincial pharmaceutical inspector may, at request of the pharmacy manager, exempt a given establishment for obligation to stock certain medicines, but this applies only on the one group of narcotics and psychotropic substances. Consequently, there is no option to dispense which part of the rank which may give rise to a conflict of conscience for the pharmacist selling. Therefore, if a medicinal product sold by a patient is not available in the pharmacy open to the public, the pharmacist should ensure that it is procured within a time frame agreed in the patient. The consequences of permanently failing the provide of product specified in Article 95 may result in the penalty of withdrawal of the pharmacy license. What the pharmacist community itself is divided on the topic. It's important to affirm that the community pharmacists is very divided on this topic. In opinion of the pharmaceutical community regarding the introduction and application of conscience clause in the professional are divided. In a survey conduct among pharmacists and pharmacy students, for example, in Poznań, in one of the biggest city in Poland, 71% of the total take the answer confirming knowledge of the conscience clause. Of those working in pharmacies, only 7% refuse to sell hormonal or mechanical contraception, and 34% refuse to sell so-called emergency contraception. Support for the conscience clause initiative was declared by 15% of those working and 65% of pharmacy students. On the other hand, a survey of pharmacists, PharmacyNet is one of the net page, shows that 37% of respondents are among those who support a pharmacist's right to refuse to dispense medicines, if it's against his or her views. 67 are against, and 4% have never thought about this issue. In contrast, in terms of public support, the vast majority of response, 76, are against giving pharmacists the right to refuse a prescription for contraceptive when it goes against their beliefs, and only 12% support this initiative. The vast majority of pharmacists who took part in the survey had never raised a conscientious objection, nor had they indeed to do so. However, when the response were asked if they had to provide a pharmaceutical service that was against her conscience, less than a fifth answer that they have been in such a situation, 5%. The figure is high enough and there cannot be ignored. In addition, it's also worth pointing that the vast majority of response, almost 60%, believe that the legal rules in Poland set for medical professions are not accurately formulated and therefore continue to be a cause of conflict. Some pharmacists believe that they have the right to invoke the principle of the conscience clause and that they should not do so because their conduct constitutes a lack of integrity towards the patient. Response also identified areas of the regulation that should be subject to legislative change. According to the response, the condition that should be fulfilled is a medical professions indeed to invoke a conscience clause should be made more specific, and patient access to certain health services and pharmaceutical service should also be carefully considered. In the opinion of pharmacists, it's also a priority to identify specific health professionals who, under current law, can invoke the conscience clause. According to the survey, according to the respondents, the main cause of ethical legal conflict regarding the conscience clause is determining which rights take precedence. Should priority be given to the right of medical professions to freedom of through conscience and religion, or to the right of the patient to receive the service in which they are entitled? In the analysis of the presented conflict from the perspective for a medical provisions, we undertake that the conflict rights are absolutely right and the professional duty. However, there is no information in the content of the right that legitimize the notion that the moral conduct of a medical profession should be a universal criterion for the assessment of an act, including the assessment of the patient conscience. The conscience of the medical professions cannot be conferred with the conscience of the patient, and they do not determine the resolution of the dispute of the question. Someone else's moral conviction cannot have a normative duty to change someone's will, as they would exacerbate in the inequality between the medical profession and the patient, nullifying the right to the autonomy. This does, I think, the respect the will a patient who invoke his or her own religious conviction in refusing treatment, and quite another for a healthcare professional not to perform a particular medical act on a ground of conscience objection. Referring to the reasoning presented in a certain medical specialization allows to write in a perform an activity that conviction in employee's moral conviction, there is a choice to another medical specialization should be considering. Analogies about through in a pharmacist refuse to sell a certain medical product only because of moral conviction is important. Said that is only of moral conviction, then he or she should be also consider choosing another profession. So the following conclusion can be drawn from the opinion of pharmacists. I've got some conclusion. The majority of response, the pharmacists, see the need to redefine the rules, condition, and scope of the conscience clause for medical professions. Medical profession is also the pharmacist profession. No? For them, it's included. Response believe that the specific condition should be defined and fulfilled for the receipt of health services by patient. Consideration should be given not the development for specific guidelines for decision making by pharmacists in situation of value-based conflict. The aim of pharmacy ethic classes it is to develop the ability to deal with new ethical issue raised by development in medicine. With the conclusion, I would like to conclude my speech today. Thank you very much for listening.
Thank you very much for the very interesting presentation. Michal, would you continue, please?
Mm-hmm. Yes, sure. I have some presentation that will be much useful. I just need to. Okay. I'm not sure. Is it visible?
Not yet.
No. We can see it.
Okay.
Now it's working.
All right. Thank you. So very briefly, it's the time for finding the solutions. And first of all, I would like to say that I would like to focus on how we can implement the institutional conscience clause in Poland, of course, in the medical law. And very briefly, I know that it may be it could be boring, but in Poland, the judgment of the Constitutional Tribunal from 2015, it's a crucial moment for Poland and for the future, even now, even today, because what we know from this judgment for the future is the right to consciousness objection stems from the freedom of conscience, and the right to conscience clause is deeply rooted in the Constitution, derives directly from the Constitution. It means for Poland that the Constitutional Tribunal opened the gate to provide a conscience clause for everyone in almost every situation. And so far, nothing changed. It means that still we are in the situation that any kind of beliefs are protected by the law, and any kind of beliefs according to the freedom of conscience has those kind of beliefs have a strong position to be the ground for consciousness objection in Poland. But of course, in this judgment, the Constitutional Tribunal, it was a very good judgment. And we need to understand that Constitutional Tribunal in this judgment also gave us the answers to possible problems arising from these crucial statements. So first of all, in my analysis, I try to find a way how we should find a good balance between individual conscience and institutional norms. And there are few problems, of course, arising from finding this good balance. First of all, is community access to the healthcare, medical ethics as well. Also, the free exercise of the religion, which is protected by the Constitution. And of course, when we're talking especially about the abortion, the discrimination against the women, it's also important. So in the society, we need to find a good balance between all of those problems. And of course, I know that it may be idealistic point of view, but first of all, our legislator in the future must seek some draw lines between the claims of the conscience in a very coherent and impartial way. This is also problematic, and it was mentioned in our previous meetings that we need to find a way. Maybe should we testify the coherence of the beliefs, and also should we be, or I mean, the courts should be prepared for testifying the also let's say the role and the how deep are the beliefs are, to be honest with the rest of the society when we are using the conscious clause. So all of about what I'm trying to say, it's the equal moral integrity of each individual. This is very important to find a solution to protect the moral integrity of each individual in the situation of using the conscience clause, and we need to be prepared how we can evaluate those beliefs. And I'm going back to my propositions, the Model 1 and Model 2. First of all, very briefly, it's the model with strong institutional conscience clause. Yes, I say that we can do it in Poland. But what is the institutional conscience clause? Of course, first of all, we need to understand which could be problematic in Poland, because most of the healthcare institutions run by the state. And because in the Model 1, it's like that we treat all institutions as a moral marketplace. If we if the first step is if we treat all public institutions delivered a different medical treatment to all people as an open market, open moral marketplace, there is a possibility to create institutional conscience clause. But of course, we need to understand that in such a situation, those institutions could dictate the positions, for example, on care, information, for any moral reason, and of course, then can hire employees, and they can create the corporate policy. And of course, they can drive into the religious-oriented institution. I would like to use this phrase, religious-oriented institution. It's public, but morally or religiously oriented institution. Of course, there are a lot of problems. Of course. How we can make it? Of course, by changing internal regulations. We can put into the internal regulations these kind of provisions. In this hospital, we respect Christian values, for example. Any employee of a hospital, doctor, clinic, or other medical or surgical facility in which an abortion has been authorized is not required to facilitate or participate in an abortion. Another example is the hospital recognized the special position of humanistic values, including Christian values, or violation of the dignity of the human person is a violation of hospital ethics. So we can make it by introducing some internal regulations, and of course by those corporate policies, hiring the people with strong moral or religious motivation. The model second, the model 2 is the model when the legislation prohibits institutions from refusing treatment for moral or religious reasons. And of course, it means that in such a situation, we are facing another problem because we still need to protect individual conscience. And how can we make it if the institution refusing treatment for moral and religious reasons, and on the other hand, we have still individual conscience, and we have individual conscience clause. In such a situation, of course, there are few possible solutions. Of course, we can make it also by the internal regulations, and what we see on this page. Institution X requires pharmacies, for example, pharmacies to accept and fill prescriptions, but allows accommodation of individual pharmacists' objections. So the model 2, which was in Polish doctrine, it is a visible sign that the model 2 could be one of the solutions for implementing the institutional conscience clause, which is actually not institutional, but more individual in the institution which is refusing the some medical treatment for moral or religious reasons. In such a situation, we can also deal with the we are dealing with a situation when we need to change the law, we need to implement some internal regulations, and we can do it like that. The hospital respects the individual conscience of its employees. Conflicts are resolved in the light of individual conscience of its employees, or legal norms opposed to the dignity of the human person do not apply to professional conduct. But of course, the Model 2 has more consequences than we think. Just briefly, one consequence which I would like to say is when such hospital, for example, refused would like to refuse, right, medical treatment, legal medical treatment, would face a lot of problems. Maybe because of the protection of the individual conscience, right? Would face a few problems. Maybe this hospital needs to remove those limitations on healthcare. Maybe will be closed, or become a real secular. And this is something which is very interesting in Poland, because right now all Polish society really understand that we have the public hospitals, and the society really expect equal treatment and equal access to all legal medical treatment. So if we introduce Model 2, it could be a huge change, especially in the perspective of 10 maybe or 15 years, because some of those public hospitals became, in the light of existing of the Model 2, as a public religious hospitals. So I think it will be hard to implement, to introduce Model 2. But other problems, medical ethical rules already strike a reasonable balance between individual conscience and patient care, which is also guaranteed by the Constitution. So the hospitals or doctors may refuse to participate in the treatments for moral reasons, and this is also important to note. Before the judgment, the doctors must, or the hospitals, they must inform patient of the treatment options and refer for care. So even if the doctor refused to make an abortion, he or she was obligated to give a chance for this legal abortion within giving the proper information about the other facility, public facility, for making such a medical treatment. Now, after the judgment from Constitutional Tribunal from 2015, the doctors are not able to inform patients about an abortion at all. So briefly, Model 2, as a consequence of the individual conscience for the public hospital, it's could raise a lot of problems, because if all doctors refuse to make an abortion, for example, the abortion, the patient has no chance, at least a legal chance, to find another legal solution in such a situation, and it could be a problematic. And of course, also some problems need to take into account are that in the model, especially in the model 2, we are at least reducing the patient access to the medical care. And our constitutional tribunal in this judgment also point out that we need to focus on making solutions in such a situation, because still we have the free access to the medical care, we have the right to the medical care, and from the other hand, we have the conscience clause derived from the Constitution, directly from the Constitution. So we need to protect the free access to the medical care for all, and we need to protect the individual conscience. And our Constitutional Tribunal point out that we need to find a good solution, a good balance between those two rights. But of course, what is present in our doctrine, some of the professors argue that it is not the problem when you become a doctor to choose a specialization with is coherent with your conscience. So it's clear, if you prefer to be a doctor, you are enough smart to progress your career according to your conscience. So at the beginning, you need to decide, are you able to make, for example, abortion or not? And then you should not change it. This is what we see in the doctrine. And we see also in the Polish doctrine that it is possible to make a getonicity. It is possible to hire the doctors, which are always open to make a different medical treatment without doubts, without problems. And in such a situation, each public hospital in Model 2, if we prefer, or in Model 1, the hospitals still have the possibility to hire the doctors, which they are open to make all medical treatments for this hospital for according to the contract between the hospital and the doctor. So it seems that in the society, a very pluralistic society, those problems are not a big problems, because even if we put into practice Model 2 or Model 1, still we can offer a free access to the medical treatment, and by hiring the people which have no problem with perform abortion, euthanasia, and other medical treatments. And of course, at the end, we need to remember that this is also interesting to share my propositions, my point of view with my colleagues, with also with the Hungary, because from the European perspective, I know this document it's not. It's important, but of course it's the soft law. But we need to understand that from the European perspective, there is, let's say, strong message to rule out of the right to of institutional consciousness objection, and we need to understand that this kind of discussion about the institutional consciousness objection should be also open to our to in the context of the European perspective, first of all, and secondly, maybe also comparative perspective of the countries which has the same historical, moral, Christian background. And this is interesting how you see these things in Hungary. In Poland, very briefly, I think that we are able to introduce institutional conscience clause. Model 2, Model 1, but it's nothing dangerous. Model 2 is about real institutional conscience clause, and Model 2 is more about protecting individual conscience in the public institution. And it's absolutely understandable from the judgment of the Constitutional Tribunal from 2015, because still we have the open gate for protection of different beliefs directly from the Constitution. That's all what I would like to say. Thank you for attention.
Thank you very much, Michal, and it was a really interesting presentation, and thank you for inviting us for the debate. We will. So, but first, Zdzislaw, the floor is yours.
Thank you very much. In the last seminar in September, I said you about freedom of conscience in the judge in Poland. Today, I would like say about freedom of conscience in the profession of prosecutor in Poland. Historically, the modern prosecution service is of French origin. The prosecution service in Poland appeared in the Duchy of Warsaw in 1808, along with the reception of the new mixed inquisitorial and investigative French criminal procedure. From the beginning, the prosecution service and prosecutors played a special role in the structure of the judicial authority and the functioning of the state. The prosecution service was separated from the judiciary and state administration. It was established as a modern judicial authority for the prosecution of crimes in independent Poland. The prosecution service initially operated in accordance with post-partition regulations, and in 1928 it was unified on the basis of new Polish regulations. In the period of People's Republic of Poland, the prosecution service was based on the Soviet model, and in an organizational sense separated from the structures of the Minister of Justice. At the time, it was headed by the Prosecutor General. After 1989, there were significant organizational and systemic changes in the prosecution service in accordance with pro-democracy models. In 2016, the prosecution service was again subordinated to the Minister of Justice, who is also the Prosecutor General in Poland. In Poland, there are approximately 6,000 prosecutors. The legal status of prosecutors is regulated solely by the Act of 28 January 2016, the law on the prosecution service. The Polish Constitution of 1997 unfortunately lacks any legal guarantees for the prosecution service and prosecutors. Each prosecutor and prosecutor's assessor is obliged to observe the Code of Professional Ethics for Prosecutors, adopted by the National Council of Prosecutors by the Public Prosecutor General on 12 December 2017. In none of the above mentioned sources of law will we find an explicit statement of the prosecutor's right to conscientious objection, let alone the conscience clause. The lawyer's conscience and the text of the prosecutor's oath before taking office, i.e., before commencing professional activities, each prosecutor and respectively each prosecutor's assessor takes an oath with a strictly defined statutory content. A prosecutor and a prosecutor's assessor take such an oath before the Public Prosecutor General. The text of the oath is directly provided in a specific corporate act and cannot be shortened, extended, or changed by the individual taking it. This text contains important guidelines that a lawyer should follow not only in the exercise of his profession, but also in his private life. Therefore, the prosecutor, on the occasion of his appointment, solemnly vows as follows: to perform the duties of my office conscientiously. Also, the provisions of professional ethics dictate that the prosecutor performs duties conscientiously and reliably. In my judgment, on the basis of the dictionary of the Polish language, it should be stated that the word conscientiously refers to a different semantic field that the performance of that is in accordance with at law and conscience. The first word, conscientiously, stresses rather accuracy, fidelity in performing duties, which don't always have to be consistent with the lawyer's religious or ethical views, but must correspond to the legal, e.g., secular norm and the manner of its implementation, its interpretation, which means that they can be interpreted independently of the sphere of ethical and religious experiences. In my opinion, these two statutory formulations are sufficient legal guarantees for the judge to be able to legally invoke his conscience, but to a narrow extent his impartiality in administering justice, i.e., in passing judgments. Each prosecutor and finish the oath with the words, "So help me God." The prosecutors have had this right since 1st October 2001. Similarly as judges, the limits of the prosecutor's freedom of conscience in practice. Each prosecutor and prosecutor's assessor should comply with the law and the principles of prosecutor's ethics. The main duty of the prosecutor is to undertake actions determined in the acts following the principle of impartiality and equal treatment of all citizens. The main duty of the prosecutor is to act in accordance with the prosecutor's oath. The prosecutor should guard in the seriousness of the profession while performing professional activities and during non-working hours and avoid anything that could bring detriment to the dignity of the prosecutor or weaken confidence in his impartiality. The Code of Professional Ethics for prosecutors requires each prosecutor to perform activities conscientiously and reliably, undertaking them without delay so asn't to expose the participants in the proceedings and the state treasury to necessary costs. In addition, the prosecutor mustn't yield to any influence that violates his independence, and in the event of their occurrence, he is obliged to inform his superior about the occurrence of such circumstance. Establishment of appointment relationship with a principal a particular prosecutor is preceded by a long-term and meticulous competition procedure in which each candidate is subject to thorough verification and analysis of professional, but also ethical and psychological stability. The idea is to eliminate people who don't guarantee the proper exercise of the profession of prosecutor. In the event of any infringements, the authority of the state and the particular professional group, the professional environment would be endangered. The prosecutor is obliged to remain detached from the accused, the court, the conduct case, as well as the lawyers in the trial. A prosecutor unfortunately doesn't enjoy full freedom and independence in the performance of professional activities because he has to carry out orders of his superior. But a prosecutor must be free from the influence of the media and other parties. He must avoid the so-called conflict of interests. For example, prosecutors may not undertake to conduct a case against a person close to them, e.g., wife, husband, common law wife, husband, child, parents, grandparents, brother-in-law, and against a person with whom they have a serious personal dispute, e.g., a neighbor, or for or against a person with whom they have a special camaraderie of professional affinity. A prosecutor, like every person, has the right to express conscientious objection. But the question arises whether it is always possible to answer this question. Two situations need to be distinguished. How a prosecutor acts in the courses of professional activities and how a prosecutor acts in private life. The question should be asked whether a prosecutor can evoke conscientious objection. The first, just as every person, he has a constitutional human right to freedom of conscience and religion as guaranteed by the Polish Constitution of 2nd April 1997. Article 53, para 1 and paragraph 2. Paragraph 1, paragraph 2. Unfortunately, the prosecutor's corporate law doesn't provide for such a possibility. Thus, the cases that may create a conflict of conscience in a prosecutor are criminal and civil. Criminal, age defense of the accused for murder of a person, murder of a child, pedophilia, rape, accusation of abortion, euthanasia, destruction of human embryos, crimes against religion, e.g., insults of the crass insults of the beaver, murder or abuse of an animal. Civil. AG defaults or compensation of the defended priest or parish for pedophilic acts and similar cases, also cases for registration of refusal of registration of homosexual unions, marriages, and cases for or against LGBT people. In the light of the above considerations, a prosecutor cannot refuse to accept a case that creates conscientious objection in him, because his conduct would be contrary to ethical and professional principles. However, in practice, prosecutors in Poland deal with cases that raise conscientious objection in the following way. They may excuse themselves from holding the case. However, they may not exploit this exemption without a valid reason. The right to exemption consensus cases of familiarity with the defendant rather than a negative attitude to the subject of the case under consideration. The finish. Thank you very much.
Thank you very much for the presentation. So let's move to the Hungarian side. Adam, would you please start?
Thank you very much. So today I would like to make some proposals on the topic of freedom of conscience and teachers. On the two previous occasions, I summarized and grouped the most important aspects on the basis of the international and Hungarian legal literature. I will now summarize my conclusions, findings, and recommendations related to that topic. Although teaching would appear to be an occupation considered central to a country's development and well-being, international researchers report difficulties recruiting and retaining teachers even in the most developed countries, including Poland and Hungary as well. And I don't need to prove that the basic problems of conscience presented earlier are closely linked to employment difficulties, which adds to the relevance of my proposals. Basic types of conflicts of conscience, according the literature and my interviews conducted by me, are first material type, or in other words, financial conflicts. Second, conflicts of professional nature. Third, personal conflicts. And fourth, there are mixed ones as well. I have at least one proposal in each of these areas. So, as I mentioned earlier, issues related to strikes and civil disobedience were among the most frequently mentioned conflicts of conscience among teachers. In the very beginning of this year, the Hungarian Constitutional Court concluded in its decision that the right of children and young people to education takes precedence over all other rights, and therefore did not consider the serious restrictions of their right to strike to be contrary to the fundamental law of Hungary. In contrast, as I have mentioned it last time, Balázs argued in his dissenting opinion that this ignored, that decision of the court ignored the essential content of the strike, That means ignore the element of pressure on the employer. And I have to add that this reasoning, this argument of the decision mentioned reflects a flawed attitude, a not proper attitude based on which the child is the central actor in society today. Everything happens around and for the child within our societies. A century ago, society was built around the elderly, the heads of families and the elderly. Today, this has changed completely, and another unhealthy situation has emerged. The Constitutional Court of Hungary has also miscalculated because the teacher is as important player in education as the child, even if the immediate aim is to improve the child's well-being. This is also supported by the Public Education Act here in Hungary, a third article of which states that at the center of public education are the child, the pupil, the teacher, and the parent, whose duties and rights form a unit. It's clear to see that the distorted view of society is often reflected in the misapplication of the law, sometimes even by the constitutional courts. My second finding or proposal is closely connected with the fact that research on conflicts of conscience within the field of public education also shows that the latency, the number of cases that do not turn into legal proceedings, is very high. Accordingly, for further research in this area, it's not enough to examine certain legal cases, but documentary analysis, for example, analysis of resignation declarations and interviews with people who have already left the sphere, could help to get a more accurate picture on the main types of conscientious conflicts. So, the nature of the current conflicts of conscience cannot be inferred from legal cases alone, because some of them do not reach a legal type of resolution. That is, they do not go to court, and others only become available after years of long proceedings. How then can this question be examined? In the international literature, there are several examples of publicly available termination letters of teachers that have been examined and used to draw conclusions. Those termination or resignation letters show the current situation relatively accurately. My third proposal seeks to refer to the easing of the entry and employment conditions for teachers. The detailed rules in several cases also allow for the possibility of teaching without a proper degree or even a teaching qualification. Government decree on the implementation of Act 52 of 2023 on the new careers of teachers, adopted this year, within its articles, significantly relaxes the rules makes the rules easier for the entry and performance of teaching posts. This is also a dangerous direction from the point of view of conscience issues and their institutional implications, insofar as it could lead to motivational problems for both those already in the profession and those preparing to become teachers. Fourthly, according to the Act on Complaints and Public Interest Disclosures, which has been adopted by the Hungarian Parliament this year, also the primary and secondary schools must set up a whistleblowing system. There is an obligation to establish an internal procedure for the protection of whistleblowers by creating new forms to facilitate reporting on abuses within all these institutions as well. By that regulation, a more complex system of rules on unethical behavior has been set up, but these institutions still need to be transposed throughout the legal system, not just in a single piece of legislation. On the one hand, these institutions must be included in codes of ethics, for example, Hungary's National Teachers' Chamber's Code of Ethics for the profession, schools' internal rules, collective agreements, and so on. On the other hand, their practical solutions and possibilities must be taught in attendance training courses, so that they do not become means of abuse and thus also a problem of conscience. These courses can also be used to build up and fill in the missing culture of conflict management here in Hungary, with an importance that goes far beyond the direct goals of those courses. Fifthly, we can also observe that in the most developed countries or societies, there is a huge amount or high level of legal awareness. Publications summarizing the rights of students, teachers, and parents are widely available. Interestingly, in Hungary, this is still scarce. Those books or leaflets are missing. Books written in Western countries, like The Legal Aspect of Teaching, address questions related to teacher contracts, dismissals, collective bargaining, child abuse, copyright laws, and so on. Another book mentioned by me in July, named Teachers and Students' Rights, explores legal issues related to the scope and limits of personal freedom of expression, covering such topics as religion and conscience, privacy, homeschooling, multicultural education, racial discrimination, free speech, and so on. And we do not have such compilations here in Hungary, especially in an updated form, in spite of the fact that their availability would not necessarily increase the number of disputes, number of legal disputes, but rather an awareness of behavior, and could prevent many uncertainties and conflicts of conscience and depression. And my last proposal mentioned here is a new challenge that we must meet. In dozens of countries around the world, military education as a new subject has been introduced simultaneously in public education over the past year, within the very last year, quite often is named as military sciences. And OECD countries, OECD members are among them, and also among the countries planning to introduce similar trainings or courses within primary or secondary schools. Public education in both Hungary and maybe in Poland should be prepared in advance for the teaching of this subject and its conscientious and other implications if it happens. Obviously, there are other connections, some of which I will set out in the paper, and some of which are more political than regulatory, technical, such as the issue of incomes and salaries of teachers. So I'm not going to speak about those issues today. Thank you very much.
Thank you very much, Adam, for dealing with this really important and interesting topics. not just as a scholar, but also as father of school kids. I'm very interested in your research. Balázs, the floor is yours.
Thank you. You may not be aware that with Loran we have a very complex work relationship, and one of the fertilizing elements of our working relationship is that he is, I would say, a very firmly believing Protestant, and I'm happy to be a Catholic. And strangely, we have remarkably different approaches on a set of issues that could have roots in denominational differences, and although in the vast majority of issues we have very much the same vision on 99% of issues, but this 1% difference is I think still of interest. And at the end of this whole research project, I had to find out that I'm still not fully aware about the fundamental notion of conscience. I mean, what truly conscience is. And I had to begin to do some non-legal, to discover some non-legal stuff on the issue. I also, one of my discoveries was my late discoveries that maybe the most important author on issues of conscience happens to be a Polish person, Karol Wojtyla, if I'm not mistaken. I mean, his very important work, Person and Act, is basically the philosophical background what he later has written in his encyclical Veritatis Splendor. That has a very strong vision on conscience, because when we speak about conscience in this postmodern setting we are living in, it seems to be a very individualistic notion, and what the doctrine of the church says is basically linking conscience to the notion of an objectively true and good that can be discovered by the human person, and conscience can be can have errors. It can be a distorted conscience, and conscience needs education. It's not just something you define yourself. You are not defining yourself, but there is an objective that mirrors or that has to be a constant provocation. And of course, the institution, let us say, for Catholics, the magisterium of the Catholic Church doesn't substitute individual conscience. It's only a helping instance, helping the formation of conscience. But this seems to be essential. Our level of individualism may have different historic and philosophical roots, and this doesn't necessarily mean that its conscience is or has to be linked to religion as such, but probably the notion of natural law suggested so strongly by Pope Benedict in the German Parliament it could serve as a neutral basis for our social coexistence, and we should take much more into consideration this proposal that happens to be proposed, but it's by accident, I believe, mainly by Catholics. But this could be just an accident, and it doesn't. It's not a necessity. Certainly not a theological one. But without an underlying concept of morals and an underlying concept of a distinction between right and wrong, we can't really live together. And this certainly leads to the very delicate issue of state neutrality. One of the topics I'm trying to write about in the second paper is the teaching in ethics. In Hungary, slightly more than 50% of school kids has ethics education at elementary school and not religious education. It's a free choice between ethics and religion in public schools. And when the curriculum is set by the state, where does the notion of ethics come from? The ethics suggested by the state, and I think this is a very interesting question. And maybe another point I would just rather drop in to the discussion at the conclusion of my findings. I think there are basically two types of handling conscientious objection. Some of you have already mentioned this today. Either we have just a conscience clause and we leave it open to litigation, and you should go to courts, to constitutional jurisprudence, to Strasbourg, whatever, and we can't. It should be. It is a subject of fight. It is a subject of litigation. Or we pave the way, and we offer an alternative opportunity to people. At the end of the day, this alternative opportunity can be very, very simple. And this leads to the risk that when you don't have to fight for your conscience, just to tick another box A or box B. When you just have to tick another box, then it's probably in many cases, not about conscience anymore, but about discomfort. And here we have to make another distinction. There are genuine conscientious convictions where a conflict would ruin the individual. And there are issues that are also somehow related to conscience, but they are of minor importance. They cause discomfort. I don't want to have my tax money spent for religion, and then I can tick the tax assignment in a tax assignment system. I can send money to a non-religious purpose. It's maybe not a. Certain issues are very strongly related to the identity of the individual. I don't want to bear arms and fight for the country or kill another person. Basically, that's the content of the conscientious objection to the military. But I can't say no to paying taxes that is used for military purposes, finally killing other people. So the different levels of infringement have to be taken into consideration, and for some, this very paved way of opting out can be useful, but for others, we have to leave it for the litigation, and we have to leave it for courts to find the right balance. Well, basically, that's just a short thought provocation for this morning, And probably, Laurent, it's your turn.
Thank you, Balázs, for the presentation, for the provocation, and for giving me the floor. I also, my purpose is also to provoke you. And many of you mentioned this very famous pharmacy case, and not only you, but last time I visited Poland, I was asked by the audience of a conference what my opinion was. And I had the opportunity to discuss it with Balázs quite frequently, this issue. And now I'm glad to share you my findings. Let me start with a confession that I don't want to be smart in this issue, because we have a common saying in Hungary that people from far away can say whatever they want. And we are far away from this problem. We don't know your national pieces of legislation, your case law on the issue. So we don't want to be smarter than the Polish. We just want to add some partly theoretical, partly practical aspects to this case. In Hungary, we also had quite the same issue, but it caused much less turmoil in our system. It was some 15 years ago, in 2007. There was an issue. Balázs intensely published about that, and the case was much the same. If pharmacists can be obliged to sell certain products, and that time the minister was very much against this optional purchase of the products, and there was a ministerial decree obliged practically all pharmacists to sell practically everything. And there were not really high court cases, so it was not that big case in Hungary for that. But there are some other cases that may help us giving a proper answer to the issue. One of that was the vaccination case from 2007. I spoke of that quite a lot last but one time. And so I'm not about to get back to the case again, only to highlight that according to the quite a clear praxis of the Constitutional Court, the alternative behavior must be given to all people, which means that theoretically there are cases in which conscience must prevail over the legislation. So the Constitutional Court doesn't say that every time you are free to neglect any piece of legislation, but it says that there must be a balance between individual conscience and to obey the law, but it doesn't say where this balance is. It just says the necessity of balancing. And 2 years after, in 2009, there was another interesting case that was about the registration and the denial of public oath. Before that, state officials could choose whether to take a swear or an affirmation, and the former one ended with the term "So help me God," and it was registered if you took a swear or an affirmation. And the Constitutional Court concluded, so it wasn't open for public, but it was in your file. So some people could check which kind of oath you took. And the Constitutional Court said that you can't do that. because of privacy and data protection reasons. There shouldn't be any written reference to religious background. But another part of the case was about Christian minority congregation who said that according to their faith, they are not about to take any kind of oath because this is against their faith. So for they reckon that the Bible forbids any kind of oath. But finally, the Constitutional Court concluded that the affirmation has no religious content at all. And if there's no religious content, you cannot invoke your personal religion as a kind of as a cause for conscientious objection. In both cases, both in 2007 and 2009, the court used the so-called comparative burden test. And this test has two elements. First, how close is the behavior to conscience? If it is very close to your conscience, then it's more likely to make an exception to the general rule. And on the contrary, if it is far and distinct to conscience, as Balázs mentions, it's more like a distress or discomfort and not a deep conscience, then it is less likely to make an exception. And the other element of the test, to what extent it pertains to third parties. Because if it is only about me, then it is more likely to have the exception. But if it is also about others, having nothing to do with my conscience, then it is less likely to make exceptions. So they are the elements of this comparative burden test. And now let's move to this pharmacy case. What the outcome is if we use this comparative burden test. And to be honest, I'm less in favor of the pharmacist position. Why? The first element is the relation between individual conscience and behavior. And Balázs also mentioned the level of infringement, to what extent it infringes my conscience. And I think that there is a huge difference between using a product and selling it. It is deeply about my conscience what products I use. And if I'm forced to use any product, then it is deeply about my conscience. That was my position at the case of the vaccination too, because that was about me. It's not about selling vaccines or purchasing vaccines or whatsoever, but to use them. But in this case, it is about a purchase. It's the sale of a product. I admit that pharmacists may claim that it's not just their conscience is not just to decide whether they use it or not, but also if they contribute of the use of the product at all by third parties. But I think that the level of infringement is smaller this way than using it. And what about the interests of the third parties? And I have four aspects in this way. And some of them are in favor of the pharmacist position, some of them are against the pharmacist position. First, that this is a regulated market. And this way, I think this it makes difference between some other cases when the market is not that regulated. In America, there was a famous case if confectionery is obliged to sell a cake for a same-sex couple wedding, and that market, in that case, I think I need to admit I'm very capitalist. I should have ashamed, but I don't. So that way, I think that everyone can decide if they are ready to bake a cake or not. And if I don't like the buyer, I don't bake a cake. If I don't like their money, I don't bake the cake, because it is open market. But if we speak of pharmacies, where there is a state aim, there's a purpose of the state to ensure medical products everywhere, then the individual aspects are in a smaller extent than in the case of open market. Secondly, we should also consider the nature of the product. And this way, I think that there's a difference between birth control pills and after pills. Because if there is an urgency, it's an emergency situation to use the product, but if it is an after pill, I don't have some other days to wait for the product, unlike in the case of a birth control pill, then it also makes it different, because if the buyer is in position of urgency, then it involves it has an impact on third parties to a greater extent. Thirdly, we should also consider the supply market. Is there a possibility for substitution? Because if there are 3 pharmacists next to each other, and you can easily substitute that particular pharmacist refusing to sell the product, then it is a different situation. From the buyer's perspective, no one has the right to buy a product from one particular pharmacist. From the buyer's perspective, you have the right to be given the product, but not from whom. But if there's only one pharmacist nearby, then you have less option than if there's a great variety of several pharmacists. And the fourth aspect is if there was an advance warning. Because if someone says prior to any purchase that I am not about to do this and that, and still having knowledge that they receive an allowance to run the pharmacy, then it is different than if it is accidental situation and not predictable by anyone. So foreseeability is the fourth aspect that should be considered. Then from that on, it is a regulated objection, and it is quite close to, if I understand well, Mihal's Model 2 option and Balázs's alternative behavior option. I slightly disagree with Marta saying that it's not just about conscientious objection, but pharmacists may also refuse to sell like Botox or something, if I understood correctly. I think we should differentiate medical objection and conscientious objection, because conscience is individual. We cannot say that we know the pharmacist's conscience better than they do. But if it is medical issue, then we should trust the medicine agency of the country, the producer of the medicine, and so on, because if they have licenses for that, I think the pharmacist is not in a position to question all medical and state licenses. So I think that I'm open for conscientious objection of the pharmacist, but I'm not open for the medical objections from them. So to conclude, I think that this issue has quite limited relation to conscience, but there is a relation. Considering the nature of the market and everything I had in mind, I think that there's not a constitutional possibility for refusing to sell the product on their own. Conscience doesn't give a blank check in this issue, but there should be a favorable Model 2 option. I mean that there should be a regulation for pharmacists to have their conscience prevail, and under certain criteria, they should be authorized to refuse the sale of the product. Thank you for your attendance and for your participation. And now I open the floor of open discussion, and I stop the recording.